Hi, Darin Mangum here, the PPM attorney. Just checking in again, doing a little video. Again, my blog is about doing private placement memorandums, and that's my practice. I've been doing it now for 18 years, and so this is my YouTube channel is a series of video snippets that I talk about common questions that I get as a securities attorney when I'm preparing private placement memorandums for clients. Anyway, one topic that I do get sometimes is when it comes to the bad actor disqualifications for people that are raising capital under Regulation D, Rule 506, or Regulation D in general. Recently, the Jobs Act made some changes that added disqualifications. It used to be the old Rule 505 had what we call bad boy or bad actor disqualifications. If you had a securities violations, if you had a felony, if you had any of these kind of problems, you were disqualified from relying upon the exemption. But then the other exemptions, Rule 506, did not have those kind of disqualifications, but that's changed. And so the question sometimes comes up, hey, I've had clients call me up, say, hey, I want to do a private placement memorandum, but I have a felony conviction, I have prior securities violations. Can I still do it? And so the key date to keep in mind is September 23rd, 2013. That's when the new rules went into effect. And if the bad act that the disqualifying act occurred prior to that date, September 23rd, 2013, if it happened prior to that, then you're not disqualified. You can still rely upon the exemption. If it happened after that date, then yeah, you would be disqualified from relying upon that exemption. That's not to say there may not be other exemptions to look at or other ways to raise capital. I mean, certainly we can talk about that as well, but in order to rely upon the Rule 506, you would be disqualified. But if it happened prior to that date, prior to September 23rd, 2013, then it's you're not disqualified. However, it is still a disclosure item. You still have to disclose the fact that you had that prior that event, especially if it's a material thing involving either a financial civil penalty or criminal matter. Certainly any investor would deem that to be material, any regulator would deem that to be material. And so, yes, you can still rely upon the exemption, but you'd still have to disclose that in your PPM, right? If that makes sense. Anyway, happy to answer your questions about that topic. If you feel free to give me a call or shoot me an email, and we can arrange a time to talk about your specific situation. And obviously, if you're using a PPM, making sure that you've got the right disclosures is the name of the game. So anyway, hopefully that's helpful information, and yeah, I'll be posting more, but anyway, feel free to give me a call. My cell phone number, 801-787-9072. You can feel free to give me a call at any time at that number, or you could shoot me a text as well. So anyway, thanks for watching. Thank you.